Hi guys, welcome back to my channel. Welcome to my channel if you're new. I hope you're having a wonderful day wherever you are. My name is Kseniya and I make videos for people who, like myself, are going through the family-based immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers. And the purpose of my channel is to give you guys the confidence to go through this process completely on your own. In the first half of this video, we're going to talk about whether or not you can remain in the United States after filing your petition for alien relative or adjustment of status application. And then the second half of this video, we're going to talk about whether or not you can travel in or outside the United States while your petition is pending, in regards to you being able to remain in the United States after filing your petition for alien relative or your adjustment of status application. So this is a very frequent question that I see on different Facebook forums and groups which are dedicated to asking questions about the immigration process. And very often people wonder, if my relative is currently inside the United States and I file the I-130 petition for them, can they remain in the United States? So you need to understand a couple of things. When you are filing a petition for alien relative, the I-130 petition, in itself, it does not grant you any kind of immigration benefit. It is not a visa. It is simply a form to establish your relationship with the person whom you're trying to bring to the United States. The form I-485 adjustment of status is the form that, once filed, allows the person to remain in the United States until the process is complete. Even if the person technically doesn't hold a visa during this time, their time in the United States, quote unquote, freezes, so they are able to remain and wait until the decision is made. However, you need to make sure that you understand what kind of person is eligible to file the I-485 application in the first place. When it comes to petitioning your relatives, if you are a U.S. citizen petitioning your immediate relatives, such as your unmarried children under the age of 21, your spouse, and your parents. So these three types of people, if they are currently inside the United States and you file the I-130 petition for them, you can also concurrently file the I-485 application. Once these two things are filed, they are technically able to remain in the United States and wait for the decision to be made. So no matter what kind of visa the person has arrived on, if they are an immediate relative of a U.S. citizen, they are able to remain in the United States. So a lot of the times what I see is U.S. citizens' parents come from overseas on a tourist visa and they end up staying here, and eventually you decide to file the adjustment of status application for them. And so in that case, even if their visa expired, even if their tourist visa expired, at the end of the day, they are able to remain here on a pending adjustment of status application and wait for the decision. And during this time, they will technically not be accruing unlawful presence or overstay. Immediate relatives of U.S. citizens can file I-485 even after their visa has expired, because any kind of visa overstay is forgiven for these types of relatives. So these are the only types of people who can remain in the United States after you have initiated the entire process for them. When it comes to any kind of other relatives, such as sons or daughters of U.S. citizens, so that's sons or daughters over the age of 21, or siblings of U.S. citizens, so these kinds of people are not allowed to file their case concurrently. They are only able to apply for a green card after their time on the visa bulletin has approached. And so when it comes to adjustment of status, unfortunately, in majority of these cases, because the wait times can be over 7, 10, even 15 or 20 years in some cases, they simply cannot remain in the United States for such a long time without a valid status in order to then be eligible to file I-485. So that is one thing you need to keep in mind. So if you are, for example, a US citizen trying to file an I-130 for your sibling, you have to be aware that it will be another 15 to potentially even 20 years before your sibling is able to apply for a green card. So they simply cannot remain in the United States without a valid visa. And if they end up accruing any kind of overstay in the United States without a status, then they will be automatically denied a green card because they are not your immediate relative. So that is something that you need to keep in mind. The next thing that I wanted to talk about in this video is the dangers of traveling with a pending petition I-130 or even with a pending adjustment of status application. In some cases, I do see people responding and saying, well, if you have any other type of valid visa, you can technically enter the United States even if your I-130 petition is pending. It may be true in some cases. However, you need to be aware that your I-130 petition represents an immigrant intent. And any other visa that you hold that is a non-immigrant visa, basically you trying to enter the United States on a non-immigrant visa while you have an immigrant intent in process can cause you some issues. You may be questioned at the border, and in some cases you simply may not be let into the country. I see some people respond that it's no problem, you can totally travel. However, it's something that you should do personal research on, I believe, and that is something that you would do at your own risk. Another question is, can I travel outside the United States while my adjustment of status application is pending? And this question is a little bit more tricky. If your adjustment of status application is pending, typically you should also be applying for something known as Advance Parole, which is a travel document that allows you to travel outside the United States and back while your adjustment of status application is pending. And unfortunately, this advanced parole document takes anywhere from 9 to 12 months to be processed, which is a very long time. If you leave the United States without an approved advanced parole, your application for adjustment of status will be considered abandoned, and you will simply not be let back into the country. The only exception in this case is for people who already hold a kind of visa that is called a dual intent visa. These are H visas, O visas, and L visas. These people are able to still travel in or outside the United States even if they have a pending adjustment of status application, because the kind of visa that they currently hold, it is technically a non-immigrant visa. However, it gives you a direct pathway to then be able to apply for a green card. So I hope that you found this video informational. Please let me know if you have any questions. Subscribe to this channel if you haven't already, and I hope to see you guys in my next videos. Bye!